talk about privacy. Why? Why should we talk about privacy? It's about speech. Well, turns out that speech can invade privacy, and the interest in preserving a zone of privacy for each of us is an important interest, an important value that sometimes trumps the interest in being able freely to speak. The privacy issues that we'll discuss are primarily of interest to the press, not so much to individual speakers, but can affect individual speakers. In some privacy cases, it turns out that the press is liable, responsible to pay damages, even though it publishes the truth, but invades privacy. And in some cases, it can be liable even if nothing at all is published, if the way in which the press gathers the information invades someone's privacy. And it's hard for me to gauge how much you care yourselves about your own privacy. I know your generation has a bad reputation given your attachment to Facebook and your willingness to put it all out there for anybody to see, so that one wonders how much you value your own privacy. With regard to the press, the competing value against privacy is newsworthiness. Something is newsworthy, the press wants to publish it. They want their freedom of speech in the press to triumph over your right to privacy. If I had a piece of chalk, I could draw you a pretty picture that would illustrate this, but they don't seem to have any chalk today. Okay, well, use your imaginations. This area here is all of the information about you. Whatever kind of information there is about you is there. And some of it clearly is private, and you would never want it disclosed. And some of it may be newsworthy, and that certainly the press would want to disclose it so that people know what's important about you, or something important that you've done, or something awful that you've done. And where you draw the line in this universe about what's private over here, as opposed to newsworthy over there, it's sort of a subjective value judgment about how much you care about privacy. If you don't care very much, then there's going to be a very narrow strip of information about you that is private, and all of the rest, you could say, is newsworthy. Whereas if you're a very private person who doesn't like to be out there in public and guards your zone of autonomy and privacy, maybe the privacy zone would be much larger and there would be very little that's newsworthy about you. But where you draw that line is entirely subjective and arbitrary. We could refine it a little bit, I guess, if you can imagine that whole universe of information is there, but this time it's divided into four different kinds of information. Some of the information is newsworthy and not private. That's up here. And then some of the information is not newsworthy and not private. That's over here. And then you have some of the information that is newsworthy and private. Tough one. And finally, some information is not newsworthy and it's private. So what do we do with those categories? If the information is newsworthy and it's not private, there's no controversy. You may not want it disclosed, but it's not really private. It's something in the public record, or it's a picture of you in a public place doing something that the press thinks is newsworthy. Well, they're free to publish it. If it's newsworthy and not private, you have no basis for complaining. If it's not newsworthy, but it's not private, you can say it's a stupid decision for the press to publish it. It's not newsworthy. Why would they bother? But again, if it's not private, there can't be any liability because your privacy hasn't been invaded. It's not private information. Yes, number 77 back here. What's going on? Can we put that away? Thanks. Then if the information is newsworthy and private, that's a hard case. There's the head-on collision of the two values of newsworthiness and privacy. But, as we'll see, if in fact the information can be considered newsworthy, that side wins because of First Amendment values. Not necessarily that the First Amendment determines the outcome, but because the interest in speaking to the public and publishing to the public information of legitimate public concern, i.e. newsworthy information, prevails over the individual interest in privacy. And then the last category of information that is newsworthy and private, well, that's just the one I just did, right? If it's not newsworthy and it's private, then if there's ever a situation where a person should be able to win an invasion of privacy suit, that's it. If it's not newsworthy, what are they doing publishing private, intimate information about you? Well, even that refinement on drawing the line between privacy and newsworthiness is not very enlightening. So let's look at certainly in California, definitive case that interprets the law, that explains in a comprehensive way how courts should approach invasion of privacy cases in which the information about someone is published. And keep in mind that this isn't limited to the press. You can publish information about someone by talking about them or by writing a letter, an email. You are publishing information about someone. Anyway, the case is Schulman, Ruth Schulman versus Group W Productions, the television station down in L.A. And what happened there, it's pretty well laid out in the opinion by Justice Werdiger, who's extremely thorough and lays out all of the facts and then in great detail the legal analysis that is applied to those facts. But Ruth Schulman and her son Wayne were driving on a freeway down somewhere around Los Angeles, and they went off the freeway, tumbled down into a ravine. It was a horrific accident, and the CHP arrived, and they called for the helicopter to the medevac people to come save people's lives and get them to a hospital. And they showed up, the emergency medical personnel, with a nurse and a cameraman. provided by the local television station, which was doing a series on what emergency medical technicians do and the serious traumatic events that they have to deal with day in, day out. It would make good television. And the television crew had wired the Nurse Laura Carnahan, so she was wearing a microphone, and the cameraman was visible, and they went down to the wreck, and Ruth Schulman was extricated from the wreck by the jaws of life thing, and she comes out from underneath, and the camera's rolling all this time. And Carnahan talks to Schulman in her moments of great distress, in which Ruth Schulman says some things which were kind of desperate. I just want to die. I don't want to go through this, and so on. She was, in fact, as a result of the accident, left a paraplegic. And after they got her out and her son, who was not as badly hurt, and they didn't capture anything that he had said on the audio recording, they loaded the two of them into the helicopter functioning as an ambulance, and the cameraman's right there still rolling, and off to the hospital. And later on, while Ruth was still in the hospital, her son called up and said, "Hey, they're showing our accident on television." And sure enough, she sees those awful moments in her life when she thought she was near death, when she was so badly injured, when she didn't think she looked very good, and there they are on television for everyone to see. She and her son sued the television station for invasion of privacy and made two claims. One, that the station had published private, embarrassing information, and two, that the television station had intruded on their privacy by the way they gathered the news. And what I'd like to do is first consider the publication tort, the one about publishing private information, and we'll consider that, and then we'll go on to consider the same claim in another case involving a former Berkeley student who posted some information on MySpace, and that resulted in a lawsuit, and then consider the First Amendment limitations that the court has imposed on whether on the extent to which the states can protect the privacy of their citizens with regard to publication of private facts. Then we'll come back to the second claim in Schulman, the intrusion claim, which is one of those that does not involve necessarily publication at all, but simply the way the press gets the news. So the first claim that Schulman made is publication of private facts. That's the name of the tort. It grew up in the 20th century at common law. It's a state law claim, like all other common law claims, and it has four elements. Remember, like the elements that we talked about in libel cases, well, these are the elements of a case for complaining about injury due to publication of private facts. There has to be a publication. In Schulman's case, that's easy. The television station aired the footage that had taken at the scene. That was publication. Then what is published has to be private facts. And there often is a dispute about what is a private fact. And as I hinted earlier, if it's a matter of public record, like your conviction for shoplifting, for example, and it's on the public record, it's not going to be considered a private fact. If it's a picture of you in Union Square dressed up in some silly costume, or last Saturday at the St. Patrick's Day event, spilling out into the street drunkenly doing something or other, it's not a private fact. There you were, out in public, anybody could see it. But there's a whole range of facts about you that will be considered private. One of the cases that we'll talk about just in summing up this private thing is the Rutgers dorm case, which the jury just came back with the verdict last Friday, finding a criminal invasion of privacy where the kid set up his webcam in his dorm room, pointed at the bed where his gay roommate was having sex with another guy. Certainly what you do in the privacy of your bedroom would be considered a private fact. Who you do it with would be considered a private fact. You probably don't remember, but in the first time that the nation got involved in the family values matter in presidential elections was in the election of 1988, when Senator Gary Hart of Colorado was running for president. And there were rumors that Hart was a womanizer. On a tip, the Miami Herald newspaper staked out a house in Georgetown that Hart stayed at sometimes, stayed there all night with a camera crew across the street, and they observed Hart pull up to the townhouse and get out with a young blonde woman who definitely was not his wife, and went into the townhouse and didn't emerge until the next morning. And the Miami Herald did a front-page story disclosing that Hart had spent the night with a woman not his wife. There was no litigation about it at all. It pretty much torpedoed Hart's presidential ambitions, but there was no litigation about it. Could he have sued for publication of private facts? Well, they published. Is it a private fact that he spent the night last night with a woman not his wife? What do you think? Robert?
Well, what they did was they searched him from a public area to a public area. They never went into the house or saw him that. They insinuated that they didn't make his recognition. They just said, publish facts that he arrived at someone who was stay all night in the morning.
Sounds like that story was very carefully lawyered, right? Just this side of saying he had sex with women. Okay. He's a public figure? He's running for president. He's one of the quintessential public figures. If you're running for president, you're definitely a public figure. For all purposes? Is he an all-purpose public figure, a pervasive public figure? Yeah, he is, for libel purposes. But where does that play in to the privacy tort? Does that make whatever he does not a private fact? That he's a public figure? That anything he does, there's no privacy zone around him at all? We'll get to the other two elements, which may play in here. But what you notice from the elements of the tort, there's no mention of public figure status. It doesn't matter under this tort whether someone is a public figure. That may sneak in the back door, but it's not one of the elements of the tort, and public figure status doesn't alter the legal analysis at all. Tina?
I guess you could say that he has an expectation of privacy in a private residence, but again, I didn't go into the house. I just saw him enter the house and leave. They could have been playing Monopoly while in windows. We didn't speculate about what goes on or transpires in the house.
Right. So then to go to the other two, the disclosure of the private fact has to be highly offensive to a reasonable person. It's certainly going to be, this disclosure, highly offensive to the plaintiff, to the person who's claiming invasion of privacy. That's a given. Everybody knows that. That's not enough. It has to be highly offensive to a reasonable person. This is the hypothetical reasonable person favorite of the common law, whose function is to bring some objectivity into the calculation of whether there's been a wrong here. So it's not whether it's highly offensive to the plaintiff, it's whether it's highly offensive to some completely hypothetical member of the public, the reasonable person. And finally, the private fact can't be newsworthy, because, as I said earlier, if it's newsworthy, then the plaintiff must lose. The privacy interest yields to the interest in newsworthiness or conveying information of legitimate public concern. Well, what about Gary Hart? Does any of this help or hurt his case? Is the disclosure that he spent the night last night with a woman, not his wife, highly offensive to a reasonable person? No? Yes? Yes. I mean, think about how would you like it yourself? Somebody's ratting on you and telling the world who you spent the night with last night. Surely that's covered by the concept of privacy. Are the facts newsworthy in Hart's case that he spent the night with a woman, not his wife? Are they of legitimate public concern? Yes? No? You guys got to make up your mind. One's going this way, one's going this way. Alex, what do you think? No? Because? Yeah. Yeah, but his womanizing has become an issue, or the rumors of his womanizing have become an issue in the campaign. Does that have any effect on whether you come out with newsworthiness? Yeah. So you buy into the family values ethic, and if he's a philanderer, the public ought to know about that. Sure. President of the United States. You're suggesting that his public figure status is relevant. I agree that it's relevant to whether the facts are newsworthy. Being a public figure doesn't change the analysis in any way, doesn't add new constitutional requirements, as in libel, but it's relevant to judging whether something is newsworthy. Right?
I mean, I would say it's newsworthy because as the president of the United States, inherently a pretty shitty job and a very private thing. You can't even keep like, the press away from you, there. Who said you can't cover up all the other things you cover the president of the United States?
So what are you suggesting, that everything's newsworthy about a candidate or a politician?
I'm saying this is very newsworthy because this must be the free world, and he can't even take care of himself and hide, but the patients will hide. I would say he can't hide our secrets.
And we want him to hide our secrets. Right? Okay.
But I think, like, obviously, we all have harder rights to what we want, so I don't think it's very easy to do something. But I guess I think a lot of people would find that important. Like, a lot of people might not.
Well, I mean, is that what drives our legal system? Is whether people are thirsty for rumor and gossip? That, get out of it. No, he didn't. His campaign fizzled out after that. Yeah. So he never got the nomination. His Alex? Does it what? That's where we're going. Can you put that on hold for just a second, Kelly? Yeah. Whatever sells papers is newsworthy. Whatever sells papers is newsworthy? I mean, journalists are not in the business of publishing information that nobody's interested in, right? So you could say by definition, if it's published, it's newsworthy? That would wipe out the tort of invasion of privacy. Krista? He's not running on a family values platform, but this was the first national election in which the... Yeah.